Yes, Paul. Good evening, friends. Good evening, friends. Our distinguished speaker, Dr. Rama Subramaniam, our past president and advisor, Mr. Davies Kalukaran, my dear board members, welcome all to this wonderful evening. Today, we are going to hear from an expert on cybercrime management and digital forensics, contemporary issues and challenges. We are living in a world of cyber crimes, and we hope this will be one of the relevant topic today. My job is to introduce Dr. Rama Subramaniam, today's speaker. Dr. Rama need no introduction as he is a very popular speaker and trainer and expert in this field. Many of us had heard him before. Dr. Rama is the Group CEO of Valiant Technologies Group, operating from India, UAE and Mauritius. He is the former chairman of the Board of Trustees of Center of Excellence in Digital Forensics, India, and current global chair of International Institute of Certified Forensic Investigation Professionals, USA. He also serves on the board of Cyber Security and Digital Forensics Research Foundation, USA. He served for 3 terms as India's country representative at the International Federation for Information Processing. He served earlier as global chair of E&A Committee of the Generally Accepted Information Security Principles Initiative in the USA. He served as adjunct professor at the University of Madras and at the University of Dubai, teaching a master's program in both universities. He has a multidisciplinary doctorate in the area of cyber criminology from the University of Madras, a master's degree with distinction in technology management from the University of Lincoln, UK, and a master's degree in law with honors from the University of Salford, UK. He holds FCA, CISA CSM, CASP, CEH, and CHFI, credentials and honorary fellowships of FISC and FCFIP. He is the founder president of ISC2 Chennai chapter and had served earlier on the boards of ISACA chapters in Chennai, Bangalore, and Dubai. He currently serves as co-chair of IT Committee of the Madras Chamber of Commerce and Industry. This is his introduction. He is a very popular figure in this region also. He has done many assignments and many trainings, and he is continuously supporting all the professional organizations in this region and other African region, India, and many places. If any questions you can put in the chat box, Dr. Rama will address the same towards the end. Let us hear from Dr. Ram.
Thank you very much, Jose. It is a pleasure meeting you once again today. I must recognize that there could be quite a few of my old friends in the audience, and a special warm greetings to each one of you. As Jose mentioned, Muscat, in particular among the various cities in the Gulf, has been very close to me. I not only have clients there, I have got people who I trained and have picked up over the last perhaps 10 years or so a large number of friends. And to each one of you in the audience, welcome to this program. And let's spend the perhaps next 45 to 50 minutes on considering some contemporary issues in digital forensics. In fact, digital forensics has come of age. If you go by the number of digital forensic investigations happening today across the world. But I must also tell you, before we go into the subject, that the degree of maturity in the knowledge space surrounding digital forensics is significantly lower compared to the degree of maturity, the knowledge space that surrounds conventional forensics, or what has been called traditionally medical forensics. That is a 200-year-old science, and we are probably less than 20 years old, and we're catching up with them. So there'll be issues about standardization, which we will take up. There'll be issues about knowledge levels we'll talk about. There'll be a lot of behavioral issues because most people who come to digital forensics have not come from an investigation background. So given all this, let's look at what could be some contemporary issues when we look at digital forensics. But before that, before we get on to that, I want to just tell you what this word forensics means to any one of us. Now, forensics essentially talks about collecting evidence of probative value. When I say probative value, we're talking of a situation where I have a proposition and my evidence must be such that it either proves the proposition or disproves the proposition. So a good evidence will have probative value because it will either prove or disprove a proposition. Now, digital evidence is no exception to this. Good digital evidence must have probative value in order to satisfy it being a part of good digital forensic scheme. But very, very unfortunately, what we have today, a situation where the nature of crime around which we gather digital evidence is so unique that we are struggling, first of all, to create a proposition. And if at all we successfully create a crime proposition, we are also finding it very hard to directly correlate the evidence on hand with the proposition that the crime has been committed, who has committed it, at what point of time, what methodology, what result, and what consequences. I think to understand this better, I'm going to draw for you a very simple yet, I would say, a comprehensive definition of cybercrime by Interpol. Interpol says that cybercrime is the fast growing area of crime. That's fine. More and more criminals are exploiting the speed, convenience, and anonymity of the internet. So these three characteristics, speed, convenience, anonymity, and I'll add one more, ubiquity, which is what is said later, no borders. These four factors which determine internet as of today is also a matter of concern for many of us who are in the practice of digital forensics. I will take you through some specific cases why we're saying what you're saying, and also issues like what needs to be done to understand the better part of digital forensics today. But before you get that far, before you get to technological parts of digital forensics, I would like to present to you in perspective the concerns that we generally have. In perspective, we have what is called in the digital forensic arena the problem of four languages. Now, in a typical crime scene where forensic investigators take over, the typical digital crime scene where digital forensic investigation must happen, very, very regrettably, there are four languages being spoken by the stakeholders. On the one hand, we got technologists or people who come from technology background, like myself, Joes, and various technologists here. We look at the digital evidence from a technological point of view. We ask questions. How reliable is this MAC address? How reliable is the switch through which data pass through? So we talk technology. We look at evidence from a technology point of view. And you got one more person here, a very important person, who is a law enforcement, who doesn't look at digital evidence from technology point of view, but from a purely law enforcement point of view. Now, what is the crime nature for me to book this criminal? What is the possible sections under the penal code of the country where I can book this criminal? What procedures are required to ensure the evidence is not being challenged in a court of law? How will they preserve evidence digital in nature? So the law enforcement is concerned about translating their enormous skills and knowledge, which generally works in a non-digital environment, and translate that into a digital environment. So they look at it very differently. The third are the attorneys of law, both the prosecutor and the defense attorney. Both of them say, how can I make sure that by interpreting law the way I want to be interpreted, my client will not be in jeopardy? So they look at the entire evidence from a strictly legal interpretation. And fourthly, we got the honorable judge who listens to technologists as expert witnesses, who listens to law enforcement represented by the prosecutor, or sometimes law enforcement themselves as witnesses, who listens to the defense attorney and has to make a decision based on understanding the nuances of these three different languages. I want to draw for you something that happened recently. Lord Chancellor of the Exchequer of the British Parliament commissioned a study headed by a one-man commission, Lord Justice Robin Auld, to look at the British criminal justice dispensation. Lord Justice Auld made an elaborate study of the British criminal jurisprudence system and came up with a very famous report called the Auld Committee Report. Now, what interests you and me here, that in the committee report, Lord Justice Auld refers to a set of crimes which he calls technology crimes. He discusses it in great detail. We are not going into that. But what Lord Justice Auld concludes is important to us in the technology crime section. He says rather categorically that in the case of the bench, dispensing justice in a technology crime scenario, it is essential that there should be a lay member on the bench who understands technology and whose interpretation of evidence, whose interpretation of digital evidence is of value to the presiding judge, who will decide on whether or not a crime has been committed, and thereafter, if a crime has been committed, on the quantum of sentencing. To translate into plain language what Lord Justice Auld said was to almost say the judiciary in its present format, as he saw it, did not have, is not equipped with the right kind of skill set to interpret technological evidence, to interpret digital evidence, such that the interpretation is correct, complete, and justice can be dispensed. Now, this is one more reason I keep saying the first issue that we have to face today when a digital crime goes to a court. After all, let's also remember, I don't have to worry about forensics unless I really want to get or take the whole case to a court of law and ask for a judicial system to take over the process of dispensing justice. So when we say we want to look at digital forensics, we must be able to present that forensics in such a way that these four key stakeholders, the technologist, the law enforcement of the police, the attorneys at law, and the judge, understand what exactly is being presented by us as forensic investigation professionals. Now, the other issue that we have to bear in mind is the kind of people who tend to commit cybercrime, because studying them is very, very important in understanding digital forensics. We have some statistics on the way they behave. I got a simplified version for you here. It is said to the credit of Professor Edwin Sutherland, who coined the word white-collar crimes. Professor Sutherland defined white-collar crimes in a certain fashion and did extensive research on the mindset or the behavioral pattern of people who commit white-collar crimes, and came up with an interesting bell-shaped curve and said that there are three classes of people who commit white-collar crime. I am going to later on extrapolate this classification to cybercrime and digital crimes. Sutherland said that there are who he called habitual offenders, which is the last 1.5 sigma, or roughly 17% of people. There are people who will commit a crime, whatever you do to them, arrest them, prosecute them, put them in jail, they'll come back and commit a crime. So Sutherland argued, don't worry about them because you can't change them. At the other end of the spectrum, Sutherland found that there are people who are absolutely law-abiding, who says that whatever be the motivation, I will not commit a crime. They probably are very good sources of evidence. In between, roughly 2/3 of the population, 64-65% of them, are what Sutherland called cat on the wall. They are people who say, I would like to commit a crime, provided somebody assures me I won't get caught. I would like to commit a crime to see what is in it. I would like to commit a crime for the fun of it, for the thrill of it, but I'm worried because I may get caught. I may be shamed. So I will not commit a crime. So Sutherland argued that this 60% people, if you can manage them, I think will move towards a better society. If you translate Sutherland's findings into cybercrime today, we have a different terminology. We call them the malicious people, the hackers, the non-malicious people, those who say, I'll anyway follow all the rules and regulations. And in between, we got a very deadly combination of people who are both curious and are ignorant. They're important to me because they, if they commit a crime, are the people who are a repository of evidences for us. They're curious because they see people apparently committing cybercrime. They're ignorant of the consequences. The curiosity gets over the ignorance and they commit a crime, and they constitute today the largest proportion of people from whom you and I will have to gather digital forensic evidence. I'll come back to these people a little later, but let me proceed further with a few other challenges on this. When a cybercrime occurs, from which scene I will get digital forensic evidence, the cybercrime scene is important for me because understanding that will help me understand what evidence should I gather, what forensic trail will I get, whom should I talk to, what are the possibility that the trail of the digital evidence leading to digital forensically relevant conclusion may vanish. So let's look at how does a typical cyber criminal conduct risk assessment. As all of you will know, ladies and gentlemen, a typical cyber criminal, like every other professional in the world, carries out a comprehensive risk assessment before he or she undertakes a crime. And that process, if you understand, it will become very easy for us to interrogate that person and collect from them the right kind of forensically relevant material. The first factor in cybercrime risk assessment, the fact that they look for physical comfort. Unlike conventional crime, there's no need to be at the crime scene, and you can carry out the attack from a long distance. There is no need for a physically disturbing act to be done. What does this mean for us? It means two things for us. One, unlike the conventional wisdom in criminology, which says look for evidence in the crime scene, we are saying look for evidence all over the world. Because I never know where from this attack happened. I don't know the geography from which it took place. I don't know the IP range used for the attack. So the first challenge I get because of the cybercrime risk assessment happening is that the space, the logical space within which I will normally look for forensically relevant material is almost the entire globe for me now. That's the first challenge I face. The second challenge is, unfortunately, most people do not report crimes, cyber crimes. In fact, there are various reports, including some by the ACFE themselves, which lament that many managers are absolutely reluctant to report cybercrime, which means the statistics that we get for understanding the nature of the crime, the persons committing it, the location, etc., is very hard for me to aggregate, and therefore, in the absence of aggregate data, I'm not able to formulate specific, shall I say, hypothesis for understanding where to look for good evidence. The third problem we face today is very weak legal provisions. There is a significant mismatch between the growth rates of crime, growth rates of technology supporting the crime, and the rate at which legal system catches up with those technological changes. Now, technology changes almost every week, law changes almost every year. If technology changes every day, law changes every half year. So there's a big gap because of the way in which laws become legally valid things. The fourth challenge, which we need to consider, is more a behavioral part of it, which is what drives many people into committing crime, is the failure of what we call shaming theory. In cyber criminology, we study something called a shaming theory. Now, shaming theory really talks about scenarios where the criminal doesn't want to commit a crime because one of the impediments for him is his worry that his society, his environment, his family, his locale will shame him if they got to know that he's a criminal. For example, if somebody went to a village and told the villagers, I was imprisoned for last 10 years for a certain kind of crime, surely the community is not going to look up to him, or rather they will shame him saying, oh, you've been a criminal, keep away from us. In striking contrast to what happens in normal crime, when a typical cyber criminal announces that they successfully committed a cyber crime, there is no shaming happening. On the contrary, he gets adored. Let's take an example of people like Kevin Mitnick. Kevin Mitnick, as you know, shot to fame because he's one of the earliest persons to be imprisoned for a technology crime, for hacking. He hacked the famous AT&T's billing system. That's long history. But when Kevin Mitnick came out of his prison term, nobody shamed him. He wrote a book. The book is sold today on Amazon. And the worst part is, well, worst part or the best part, whichever way you want to talk about it, the part of it is when he sells you a book at X dollars, he tells you, if you want my autograph on the book, pay $100 more. And there are a lot of people who say, I am very proud to have a book by Kevin Mitnick autographed by the author. Now, this is a contrary situation compared to shaming theory, and one of the control parameters that restrain people from committing crime does not work. Meaning, for me, it is even very hard to play on the psychology of the criminal to pick up evidence of probative value, because he will be very proud about what it is all about, and he'll be very proud not to give it to me. The next challenge is what we call the punishment severity. Very unfortunately, there are two aspects of this which perpetuate cybercrime, and therefore more areas get covered with evidence. More area coverage, less chance that I will be in a position to get the right kind of evidence. The severity of punishment is so pathetically low that people say, I'm prepared to accept it. It's not just the punishment, it's the ambiguity in determining crime. For example, I don't want to name a country, it looked a little awkward, but you probably know which country I'm talking about. There are countries where the laws say that if you commit a cybercrime and the damage done is assessed to be 5,000 local currency units or 50,000 currency units, there's a level of punishment to you. Less than that, different punishment. There is no mathematically accounting-wise valid method of determining what is the right kind of computation to get these numbers. So a lot of such ambiguities are there, which results in punishment no longer functioning as a deterrent for those who commit cybercrime, which in turn means I got a huge number of people who will be interested in committing crimes, which also means that the forensically relevant evidence is so widespread that I'll find it very hard to get what I want in the first stroke. The last of the challenges is low detection probability, because as I mentioned, in contrast to a 200-year-old medical forensic discipline, we are a 20-year-old discipline, and we still don't have full-fledged global standards. Different courts of law have set about different standards of digital forensics. Different courts of law have endorsed different products used in pickup digital forensics. Different courts of law across the world have laid down different qualification for people to be digital forensic experts as witness to the court. These are some surrounding factors you need to bear in mind. And to understand this better, I want to quickly spend a few minutes with you on the kind of people who commit this crime, because they are the source from which I'll probably get significant objects of forensic importance. There are 6 kinds of offenders who play with the system. Script kiddies are those who will be easily manageable There are people who come fresh from the college or just got into the college, learn a few scripting language like Python, write scripts, attack a system, have the fun of bringing a system down, but they just don't know how to come out of it. They'll bring a system down and will leave every possible required forensic trail. If a script kiddie attacked the system, as a forensic investigator, I'm very, very happy because I will get a whole lot of forensic evidence from a very small logical area around the system that has been attacked. Then, of course, I got a next level, crime intending, who are what I said, curious and ignorant in my diagram I showed you earlier. They intend to commit crime, but they never thought about the consequential matters of evidence being left there. So most crime intending people are also excellent sources of forensic evidence for us. Then there are groups of individuals who form into a small group so they can share the expertise and commit a crime. They also started talking about what should they do in order to not leave sufficient forensic trails. So they're a little careful, but they're not very successful. As an organized crime gang, which does a good job, it does an attack successfully, and also have developed lot of tools to ensure the forensic trail is substantially damaged or substantially contaminated, such that when you go back and pick up the trail, the digital forensic trail, you probably will not get much out of it. Then there are people who work on faith and belief. People who say, I attack because I don't like what that person does. I don't like his belief. These are people who are very, very peculiar and whom we like. These are people who say, I do an attack. I want to be seen attacking. Therefore, I will leave significant objects of forensic importance so that people can trace it back to me. Then the most dangerous, or whom we call global crime syndicates, they do two things. After successful attack, they not only remove the forensic trail, they run something called an anti-forensic program, where they deliberately plant invalid, ineffectual, distorting, redirecting forensic evidence, and the digital forensic investigator, if he is not sufficiently trained, not well equipped with his methodology, is very likely to pick up this planted evidence, planted forensic trail, and that can be a serious issue when you have to take the person to court for prosecution. So the offender types also tell us rather clearly what kind of expectations can I have when I walk into a crime scene and determine what has been happening there. So in this context, let us go on to see a few more challenges we face when we start doing digital forensic investigation. First and foremost, most digital crimes happen against intangible property. Most evidentiary material today, substantial portions of conventional forensics, which the police uses today, the fraud investigator uses today, they're all meant to be used in the context of tangible property. I lost cash. I lost an asset. I lost a vehicle. I lost something else. It's all tangible. So we have built over a period of last maybe 100 years or so a body of knowledge which talks about undertaking forensic investigation, but the undercurrent of this body of knowledge has been the assumption that the property, the asset that has been damaged, against which investigation is happening, is a tangible property. If we translate this body of knowledge into intangible property, we run into serious difficulties on finding out how do you apply the principles of forensics in investigating loss, damage, or negligent use of intangible property. I will see if I can come back to this at the end of the session. We've got a little time, but I think we're a little short of time, only half an hour over. The second issue we face today is digital crimes are all crimes that happen across the globe. It doesn't happen one place, which means my evidence is distributed across multiple locations in different parts of the world, or in different organizations, or in different parts of a country, and each of them have got different legal jurisdictions. So getting all this evidence from different legal jurisdictions is next to impossible, because many of you know how carefully police protect their jurisdiction. It's not easy for you to go to jurisdiction and say, give me, share with me what you have. It's a long drawn process. That's the second biggest challenge we face today. The third is something more basic. We still don't have a globally accepted definition of what is authorized use, what is unauthorized use of an asset in a technological sense. There is no very clear definition today saying what is authorized, what is unauthorized use of data, what is approved, what is unapproved disclosure of private information. See, in these cases, if you must pick up evidence of probative value, the presumption is I can build a proposition. If I don't know the definition of authorized, unauthorized, approved, unapproved, accepted, not accepted, I cannot build a proposition. If I cannot build a proposition, if I cannot build a hypothesis, it is very, very difficult for me to bring probative value into evidence that I gather in the investigating process. The fourth, of course, is very straightforward. We're talking about complexity in technology and computing environments. Large organizations have got disparate environments. They got all kinds of operating systems, multiple kinds of databases, multiple kinds of network infrastructure. And this presupposes that when a crime happens in a complex technical environment, the forensic investigator must have skills, knowledge, and expertise in all the elements of the environment, or he has the wherewithal through which he can pick up, collect, merge together people with expertise in multiple computing environments. Again, a very significant challenge. That I'll come to this issues and evidence gathering little later. A couple of issues we'll talk about. Then, of course, as I mentioned earlier, there are different degrees of maturity of cyber laws. So I just come to this fifth point, issues in gathering digital evidence. There are four issues we worry about. One, as I mentioned earlier, the forensic evidence science, forensic investigative science has been built on the basis of tangible evidence, whereas intangible evidence is very different. One biggest difference is an inherent control built in the investigative science covering tangible asset is a control called limit to what you can carry away. If you walk into an organization and you want to probably carry away a file from there, unless the security knows the importance of a file, it won't alert its attention. You take a pen away from the organization, it won't alert attention. But if you take a table away, surely somebody will ask you why I take the table away, because our training has been that the larger the object, the more attention goes towards it when the object's value is being diminished. Whereas in the case of intangible asset, that hypothesis does not work, because it doesn't matter how big the file is, I can allocate that into a small thumb drive in my pocket and take it away. So the training which many of us have got, watching for large physical sizes, will not work in the case of digital laws where even without taking something away, by affecting the integrity of a file in a system, I can still manage to get away with what I want to get away with. So this is one thing that requires a mindset change. The second challenge I've faced in many cases is what we call commingled data. The rules of evidence say very clearly that when an investigation has to happen and you are looking for evidence and you know that the evidence relating to a crime is available in one place, law enforcement has a right to go to the place, or what they call raid the place, and pick up the evidence. But the caveat here is law enforcement can at best pick up evidence directly related to the crime scene. Let me give an example. Let's assume that I'm a connoisseur of paintings. I go and buy paintings in a shop or in an auction. Let's assume I got some 50 paintings bought in a shop. I have displayed that in my walls or my living room in a house. I unfortunately suffer from a disease called kleptomania. Kleptomania is a disease that will tempt you to keep stealing something involuntarily. So as a kleptomaniac, I go pick up a painting, steal a painting, bring it to my house and keep it there. So I got 50 originally paid for paintings, one stolen property. And there's a complaint about the stolen property. The police knows this is me. They come around and say, we would like to investigate that whether or not you got the painting reportedly stolen. So they find out the painting and take it away. The question here is, what can they take? They can only take away from the house suspected stolen property and not everything else, because the law very clearly says you can only gather evidence that which is directly related to the crime scene. A typical computer crime scene, the police goes to a place and finds that a stolen property, namely a stolen intellectual property, is stored in a file on the laptop or a desktop. Now the problem is, how will they take it? It's a commingled data. The hard drive has got the stolen IP and the normal working files also. If the policeman says, I will copy the file, my first challenge is, this is not original evidence, copied, therefore contaminated. So can he take away the entire hard disk? He can't, because he can't take commingled data. There are different legal systems in the world that have got different answers to this question. But because we talk about evidence from different parts of the world, the absence of a uniform legal response to this is a matter of serious concern for us. The third is a very old issue I've been talking about. In criminal jurisprudence, we got something called MOM, means, opportunities, motives. If you must prove a crime, you must demonstrate the criminal had the means of committing the crime, the criminal had the opportunity to commit this crime, and the motive for committing this crime. When you translate this into a typical digital crime scene, it's very difficult to prove it, because the ubiquity of the internet gives every one of us the means for doing it. Ubiquity gives every one of us the opportunity for this. Ubiquity also gives every citizen the means, opportunities, and motives. In effect, the 7 billion people who are on this planet have equal MOM, and the old wisdom of jurisprudence saying prove MOM is no longer valid in the case of digital crimes, and therefore evidentiary material is also becoming a little tricky in this case. Finally, one of the concerns we talk about is search warrants. There are conflicting views on how do you have a search warrant issued for a digital forensic evidence, because that's an intangible asset which can move at the speed of light, and it can move without leaving a trail, and you can make multiple copies of it. Which copy will the warrant take as valid? We have no answers to these questions. Legal luminaries, jurisprudence specialists, jurists, judges, Professors of law have been talking about this for generations together now, and we don't have an answer for this as of today. So let me leave it at that and go to little more specific issues. I'm going to talk about three disruptors, about which we keep on talking: the blockchain, artificial intelligence, and IoT. Now, as these become popular, the crime scene also shifts to blockchain, AI, and IoT. So, what are some issues in that? What will happen to us when you go to a crime scene, either in a blockchain or an IoT or an AI scene? There are 6 specific challenges we face in these disruptor technologies. So let's spend some time on them. First and foremost, we say, I have ubiquity and mobility issue that must be addressed in these disruptor areas. And the issues are like this. First and foremost, if you look at something like an IoT situation, you're talking about almost 10 power 34 possible IP addresses and IPv6. And they get distributed across the globe and they get remotely connected. Now, this remotely connected systems, which are millions and millions and millions and millions, run disparate control paradigms, because at that kind of numbers, when you connect them across multiple functions, you are not going to be able to have a single control paradigm controlling the operation. Let me give an example. As recently seen, a sugarcane plantation in Mauritius. This person has decided to use technology for betterment of sugar yield. So he has put an sensor at certain locations in the sugarcane plantation, where one sensor covers 3 sprouts of sugarcane. He has got almost some 80,000 sensors covering a couple of acres, and they keep on looking at sugarcane, ask some key parameters like moisture, whatever it is, and keep studying back to this person on a console on his desktop where sugarcane are withering away, what is the requirement for that. Now, 80,000 sensors sending data cannot be controlled using conventional means, which means that he is opening his sensor traffic to very unconventional control paradigms, which also means anybody accessing one of the 80,000 sensors has got to the network. Now, this will become a reality when IoT becomes a reality. Now, we don't have control paradigms defined for these kinds of ubiquitous mobile information flow from unconventional sources like sugarcane field or a boiler or a ship or from a house kitchen. The second challenge we got is many of tomorrow's, late today's systems operate as something called self-start mode. They are planned for self-awareness, what are called conventionally heuristic systems, the self-running systems. They self-configure, they self-maintain, and very, very unfortunately, they self-destroy or self-annihilate. I'll give you an example all of us see every day morning. You have antivirus software, right? Now, antivirus software often self-configures because the vendor pushes down a patch. The vendor pushes down an improved signature pattern. The vendor pushes down a new logic. It reconfigures itself and translates that into that organization's requirements. It does self-configuration. There are a lot of self-maintenance systems. Almost every SCADA system self-maintains. Today, the self-start property is being exploited. At the end of the day, we have people who say, I will teach this self-start equipments not need to be aware, not need to configure itself, not just to maintain itself, also to annihilate or destroy itself. So that when there is a suspicion that this self-propertied device in the system is being subject to a forensic investigation, or minimally evidence is being gathered from it, the command will be self-annihilate. Destroy yourself. That destruction, destroy evidence also. The third is heterogeneity. There are mushrooming number of ID conventions, timestamp formats, packet header formats, and we got today a mushrooming number of non-traditional objects of forensic importance. Let me give you a small illustration of this. Look at this cartoon, which talks about a toaster. And this person says, I don't know how it happened, but there is an applet in the toaster, and some guy in Norway keeps burning my toast. This is not a fairy tale, it's a reality trait, which means in turn, I should be prepared mentally to look for digitally relevant evidence in a toaster, which is a smart toaster. So the number of smart devices around you so enormous, it might go out of my imagination to understand where will I lay my hands to pick up contemporary digital evidence. Then we have got the dual presence characteristics. Today, most of them are locally controlled and remotely controlled. Any one of them is good enough for me to damage the evidence. And worst part is the local control and remote control has varying timestamps, varying formats, because today's equipments can read multiple formats. Then, of course, you got heuristic response. We talked about it earlier. It helps people having zero evidence. And finally, my biggest concern about all this is standardization. By 2020 end, that is last year end, we had 50 billion connected devices. Please understand, ladies and gentlemen, 50 billion devices are connected, of which roughly 30 billion were smart, meaning they were participating in multi-way communication. The estimates are that there are trillions of communications happening between smart devices. The enormity of data generated is so large that they will flood, they will close, they will hide what we call objects of forensic importance. Just to give an example, a connected car. I'm not talking about smart car. I'm not talking about driverless car. I'm talking about normal connected car, like the one you drive, a BMW or a Benz, which has got an onboard computer. That generates, one car generates 25 gigabits of data per hour. Now, what do they do with this data? If this is the rate of data generation, and when the cars get connected, they become smart, they talk to each other, the amount of data transferred on open networks, car to car, car to garage, garage to garage, garage to owner, will run to trillions of trillions and trillions of bytes of data happening every 1 hour. Please understand, all these are non-standard data. The same data that the onboard computer on a BMW uses to understand the gear functioning, shift functioning, is different from the format used by Benz with the same function, understanding functioning of the shift in an onboard computer. Now, this is the case in which you're going to get into the system and say, I want to pick up evidence of forensic value, evidence of probatory value, which I can take to a court of law, convince the honorable judge, make him understand what I'm talking about, and pass a judgment. In between, I got attorneys interpreting it, technology is coming and adding confusion, and the policeman saying, how much can I prosecute? Given all this, there are two things that happen in future. One, we as digital forensic investigators will never ever have a dull moment. Two, if we do not standardize the digital forensic process, a time will come when the judiciary, the legal fraternity, and the common man might start asking questions about the veracity, the respect for digital forensic investigation process. So wherever I speak, I leave the speech with a request to the audience that whenever you find an opportunity, please support the standardization process started by multiple organizations in the world, because very soon we should be in a position to say, like the medical forensics people tell you, Like the financial forces people tell you, we have got a globally acceptable, ubiquitous standard for digital forensic investigation. Ladies and gentlemen, I'll stop here and let me thank you most sincerely for your time being here this evening. And I'm sure you might probably have some thoughts to share with me. I'll be delighted to hear from you. Thank you very much.
Thank you, Dr. Rama. And if anybody having some questions, you can ask. I think you one or two questions are there. Does the law enforcement means that local FIU?
Jose, can you repeat the question? I think I lost you somewhere.
Does the law enforcement means the local FIU?
What is
local
FIU?
FIU? A financial intelligence unit.
Okay. It may be the FIU. It can be any crime intelligence unit because in a typical digital crime scene, it can be a local cyber intelligence unit also. So mostly it will be cyber police that will handle this.
Oh, the question was from Alfred Reich. Any clarification required, Alfred? You can type the question again if anything required. Then second, I want to see slide 1 from 6. Okay, I think the presentation material will be shared, right, Doctor?
It will be. Yeah, I'll send it to you today after the session is over. Share it with them.
Yeah. Okay, that presentation materials will be shared with you by email. All the attendees will get that. Any other questions? I think our allotted time also getting over.
Yeah.
And if any further questions, you can send email to ACFE Oman at gmail.com. So we will address it separately. And thanks a lot, Dr. Rama, for the excellent and very informative session. Thanks to all my co-board members for the support and guidance provided to execute this seminar. Thanks, Murad Al-Balushi, for taking care of the social media part. Thanks to all attendees. Good night to all. Take care.
Good night.
Thank you. Doctor, can you stop sharing? Yeah.